Good afternoon, everyone. My name's Nicola Handley and I'm a Senior Associate Solicitor based in our Leeds office at Irwin Mitchell. Firstly, I'd like to say thank you to everyone for joining us today for part 2 of our series of webinars focusing on the coronial process and civil claims and how we can best support bereaved families. Before we get started, I would just like to share some information about Irwin Mitchell for those people who may not have met us before. We are a full service law firm specialising in a number of client services, including personal injury, public law and human rights, medical law and patient rights, family law, commercial issues and much more. Many of us at the firm also regularly support families through the inquest process. I've personally supported many clients through the coronial process following the death of a loved one from an asbestos-related disease, and really do appreciate how overwhelming and complex the process can be at a very difficult time of people's lives. Today's webinar is going to focus on evidence and conclusions, and we are joined by 4 speakers who have kindly offered to share their experience and expertise. Firstly, we'll hear from the Deputy Chief Coroner of England and Wales and His Majesty's Senior Coroner for the City of Sunderland, Derek Winter. We will then be joined by Michael Rawlinson KC, a leading barrister who specialises in personal injury claims and has extensive experience in supporting families through the inquest process. And finally, we will be joined by our clients, Lesley and Neal Davison, who have sadly personally experienced the inquest process following the death of their daughter Megan in 2017. Please note that we will be recording today's webinar, and a copy of the recording together with the slides from the presentations will be circulated to all attendees. Please do also ask any questions that you may have using the Q&A function. So over to Derek now.
Thanks everyone. We'll move straight to the role of the Chief Coroner just to set some context for you. So if that slide could be put up, please. And you can see for yourselves what the role of the Chief Coroner is. First Chief Coroner Sir Peter Thornton, KC, and these functions have been in place now for quite a few years, as many of you know, to promote consistency amongst coroner areas, of which we're now down to 77. So moving to the next slide. Just to give everyone some perspective as to the workload involved in death certification, you'll see from the coroner returns that each coroner makes every year to the Ministry of Justice that just short of 600,000 deaths in England and Wales, about a third to coroners, and culminating in just short of 37,000 inquests. So they're the deaths which are basically unnatural or deaths in state detention. And if you want to look at your coroner statistics, I've put the link there, and go to the data visualization tool. So the next slide, please. As of the 9th of September, we now have a dual system of death certification. We have medical certification of death by a doctor following scrutiny by a medical examiner, and we have a clear judicial certification of a death by a coroner in accordance with Section 1 of the Coroners and Justice Act 2009. Moving on, please. So natural causes, I've set out what my definition is, and that of Chris Dorry's, because it's not a definition which is found in the Act. And if you could move to the next slide, please. There is a cause of death list for those of you who are interested as to what could be referred to a coroner, almost an A to Z of causes of death. Next slide, please. Of course, the Touche case established unnatural deaths, and in particular what was deemed as medical mismanagement and culpable human failure, which can flip what appears to be a natural death into an unnatural one. And they're the challenging areas, I think, for coroners and medical examiners. Next slide, please. Neglect. There's the definition in Jameson. Families will complain about neglect in a variety of settings, which the coroner will investigate. But I do remind everybody about Chief Coroner's Guidance number 17, and the fact that neglect is to do with something, a failure that is basic. And the Chief Coroner there confirms that coroner's not there to criticise every twist and turn of a patient's complex clinical treatment. So some further context in the next slide, please. If it's an unnatural cause of death, we're going to be having an inquest in every unnatural death case. So next slide. They're the rules of engagement with coroners, which were brought into effect in 2013. Next slide, please. And to promote consistency amongst coroners in 2019 came about the notification of death regulations with associated guidance from the Ministry of Justice, which essentially pads out the Section 1 requirements for coroners and deaths that should just go to coroners. So next slide, please. The next few slides just elaborate upon these fairly obvious referrals that are necessary to a coroner, including the next slide. And again, you can see the cause of death was unnatural. The cause of death is genuinely not known. Somebody dies in custody or state detention, and of course, where the identity could not be ascertained. Thank you. To the next one. So the duty to investigate, as we know in Section 1, that's a reminder for everybody. All of the other deaths that I've referred to from the statistical analysis will in future go to the medical side, where the doctor will sign the medical certificate as to the cause of death, scrutinised by the medical examiner, so that all of those hundred thousands of deaths will either have a scrutiny or an investigation. Thank you. Next slide. So if a referral is made under the notification of death regulations to a coroner and say after post-mortem examination, the death turns out to be natural, then if there's nothing else to worry about, the coroner will discontinue the investigation. So only those that are unnatural, violent, or in state detention are going to find their way to an inquest. So this funneling process is a constant activity in a coroner's office as to what will proceed to inquest. Thank you. Next one. In some cases, referrals are made to coroners, and those who may not yet know, a coroner need not just keep the referral from now on. The coroner can decline jurisdiction and send it from the judicial world, the judicial system, into the medical system. And that should relieve coroners of dealing with unnecessary natural deaths, and they should be able to get on to deal with their inquest work, and hopefully the backlogs will reduce. Next slide, please. Post-mortem examination, really important if there's absolutely no cause of death which is clear from the records, or possibly following a scan in lifetime. It's the coroner's request for a post-mortem examination. The family, of course, will be involved in that process and the necessity of it. But again, it's up to the coroner to make sure that the family are at the heart of the process and kept informed. Next slide, please. Section 14 is the power, and you can see I've made reference to second post-mortem examinations, sometimes called the defence post-mortem examination. Chief Coroner's Guidance 32 deals with that, and should further examination be required, there will have to be a submission and application made to say why that's necessary, and a desktop review cannot be undertaken. Coroners do not want to have unnecessary examinations, and some families feel that the defendant is essentially having further rights over the body. So we've got to be very, very cautious with that. And of course, we should be releasing bodies as soon as reasonably practicable. In homicide cases, although 28 days is mentioned, I personally, and I know lots of other coroners do, lay down very strict time limits for the early release of bodies so families can have their funerals. And then next slide, please. I can skip over this, but it's a follow-up report following Hillsborough and various issues for pathology to address. But the next slide. In the North East, we followed examples from Leicester and from Lancashire with the use of post-mortem CT. Essentially, in appropriate cases, instead of loved ones being subjected to invasive examination, a person can be scanned overnight, and hopefully we can get a cause of death, the cause of death, without invasive procedure, or only partially invasive if absolutely necessary. It's not appropriate in all cases, but certainly our families very much appreciate the possibility of a CT scan, for which it costs no money for them. It's funded by our local authority, who fund my service alongside other coroners in this area as well. Next slide, please. So with investigations, the next few slides just set out some of the questions that I'm asking my team to look at. We always speak with families about concerns that they may have to see whether we can address those and to build evidence ready for an inquest if that's going to be needed. But next slide. We will look at all of these evidential aspects, in particular whether a protocol or a procedure exists and if it has been followed. And it's really important that there is a sufficient and thorough inquiry. So into the next slide, please. Interested persons, section 47 is a useful reminder about the extent of the list of those who may have an interest in the inquest process. Being an interested person brings with it the right to disclosure and the right to ask relevant questions at an inquest. So this is a very serious ruling on the part of a coroner as part of their investigative process. And it includes people with a sufficient interest. And by that, I would include perhaps a neighbour who's cared for somebody who's got no friends or family. And it's really important that coroners take due note of interested person status. Next slide, please. So inquests, we should open them as soon as we can. We should set dates. People work better to dates and timescales. Inquests, as you all know, are heard in public. We have facility for remote participation, so via Teams usually, and there is provision for remote observation by the media and the public on application if it's in the interest of justice to do so. We also have the ability to do inquests in writing where the outcome is agreed and there's nothing contentious. All of our hearings have to be recorded digitally. We're no longer asked for CDs. Lots of people don't have CDs these days, so we provide a link. And the target date for inquest remains at 6 months, or as soon as reasonably practicable. So into the next slide, please. I like to do directions hearings, pre-inquest reviews in cases where there is a degree of contention, identify interested persons, the scope, Article 2, if a jury is required, provisional witness list, who's coming, whose evidence can be read, dates of any next hearings, the length of the inquest, when it's going to be heard, the venue. And if we're going to have an expert, then we'll do a joint letter of instruction to an agreed expert that I will fund. And of course, we have established expertise with the Health and Safety Executive, Health Safety Investigation Branch, our road traffic collision investigators. But if an expert is required, a pre-inquest review is a good idea to identify that expertise that's going to be called to give evidence. Next slide. Inquest disclosure. Even before the changes in 2013, I would provide disclosure. Information is power. Families should have that. They should not have to struggle to get disclosure. Very often it's electronic, but it can be paper-based if families do not have facilities to access the disclosure. Although the rules provide that the families have to ask for it, the reality is that they won't know to ask unless you tell them. So we will share everything that we can reasonably share with the family. There are some restrictions there if it's irrelevant or unreasonable, or if there are some copyright issues or pending criminal proceedings. But generally speaking, the disclosure, in my view, should be proportionate, and it should not really be a dry run for a civil action. Remember, the inquest is there to establish who the person was who's died, when they died, where they died, and how they came about their death. So at a pre-inquest review, for example, I will ask the family, the advocates, to direct me to the pages of the medical records, for example, that they will be referring to, so we're not swamped with paper or electronic exhibits. And of course, disclosure is without cost to the recipient. Next slide, please. So A reminder of the inquisitorial nature of the inquest. Coroners can't appear to determine any question of criminal liability on the part of named person or civil liability. The Court of Appeal case of Morahan holds true that an inquest is a relatively summary inquisitorial process, and we should bear that in mind. To the next slide, please. There are the short form conclusions, all in the balance of probabilities as the standard of proof. That is more likely than not. There are 10 short form conclusions, and many coroners use narrative conclusions, which are usually a brief, neutral statement of facts as the coroner finds them to be. So perhaps in a clinical case, a coroner might say somebody had died from recognised complications of a necessary surgical procedure. It doesn't offend any of the rules. To the next slide, please. Just a word about suicide. Obviously, the person must have killed themselves and intended to do so. And that's a very difficult evidential situation on occasions. The recent case just a few weeks back, Sharon, was a reminder from Mrs. Justice Hill that we should not say commit suicide. It was decriminalised in the 1960s, and we should not make reference to suicide notes. What we should do is to say somebody had died by suicide or that they'd left a final message. We have to be very careful with our language, and that includes never ever saying that a body is the property of the coroner. We have to be far more sensitive than some of the cases in the past. The rest of the slide you can read at your leisure. The next slide, please. Most families, in my experience, come to the coroner's court not to see people disciplined or subject to regulatory action or as a prelude to a damages claim. Many families say to me they just don't want this same thing to happen to somebody else. And the coroner's public health function is really very, very important. We have a duty rather than a discretion to write prevention of future death reports if coroners are concerned about something which has arisen during the course of the investigation. And we write those reports to an organisation or an individual who can make a difference, and they must respond within 56 days. The Chief Coroner's Office has a publications policy to ensure that perhaps information about suicide is not shared to avoid copycat actions or problems with particular locations. Responses are due within 56 days, but there are no powers of enforcement for a coroner once the report is written. And there are some recent cases of Dillon and Garani confirming that the actions of the coroner are very subjective. They are the expert decision makers in this regard, and coroners don't need to hear submissions about prevent future death reports if they don't wish to. Sometimes coroners will, sometimes an interested person may weave evidence into the hearing to demonstrate that a concern has been identified and has been addressed. But these are really important functions for a coroner, and they listen very carefully to the evidence and take their responsibilities very seriously in this regard. And all of the documents, the reports and replies are published on the Chief Coroner's website, and I've put the link there for you to have a look at. Next slide, please. Some further reading. Lots of publications, lots of reports, lots of guidance on the Chief Coroner's website. We're now up to guidance 47. There are 5 law sheets there. And if you move to the next slide, please, you can see some work that the Chief Coroner's Office has done with competencies in the Coroner's Court. We've done work with the Bar Standards Board and the Solicitors Regulation Authority and the Institute of Legal Executives to recalibrate the tone of inquests. I mentioned earlier on, it's an inquisitorial process, a fact-finding inquiry. We should not descend into the adversarial. There's nothing wrong with putting a difficult question to a witness, but the manner in which the question is put can sometimes leave a lot to be desired. And the competencies are there for all to see. And there are some videos from myself, the previous Chief Coroner, some lawyers who do a lot of inquest work, and the Coroner's Court Support Service, who provide fantastic volunteers to support families and others at inquest. And then finally, next slide, some useful contacts. And finally, next slide, that is finally. Thank you very much for listening. It was a rapid run through, but you're welcome to have the slides. Thank you.
Thanks, Derek. That was really interesting, and it was helpful to have an overview of the evidence and the disclosure that's available to families. I think the thing that really struck a chord with me was the fact that the coroners are seeking to put the family at the heart of the inquest process and make sure that they are informed throughout. Now I'll hand over to Michael Rawlinson to talk a little bit more about evidence and conclusions in civil claims.
Mike, could you just pop yourself off mute, please? Thank you.
So sorry. Actually, you may not thank anybody for allowing you to hear me at the end of 15 minutes, but we'll give it a go. So my name is Mike Rawlinson. I'm a SILC. I do a lot of inquest work. I usually have the MOD as my fellow interested parties. And it falls to me now to spend about 15 minutes just taking you through the use to which evidence which is obtained during the coronial process in subsequent litigation. And that falls down broadly into three categories. The first is documents disclosed within the coronial process. The second is the oral evidence heard within that process. And the third are the conclusions of the coroner. And I am acutely aware that I'm speaking after the Deputy Chief. So if he says at the end of it that I've got anything wrong, I shall defer immediately. So in dealing very briefly with the documents, and there is only a small amount of overlap here with what's gone on beforehand, and just to emphasise from the practitioner's perspective, it is often the case that the documents that we are gratefully in receipt of from the coroner, because we don't get it from any other party, it always goes through the coroner, is not all that that coroner has seen. And even within documents that we do see are not always unredacted. As the Deputy Chief has already said, under Rule 15 of the rules, the coroner is entitled to say, no, I'm not disclosing because it's either unreasonable or irrelevant to the scope of the inquest. In terms of redaction, it is, however, the job of the advocates to sometimes point out gently to the coroner that the coroner, having seen the document in unredacted form, the redacted form may make sense to them, but it does not make sense to those who have not seen the unredacted form. And certainly with the MOD, you can end up with documents that are just simply a series of blanked out names, and it's impossible to follow what's going on. And that's the sort of thing that you can raise within the PIH. Of critical importance is that the documents that a party receives from the coroner, are held in confidence. And there is a complete similarity here between the confidence that attaches to the document from the coroner and the confidence that attaches to a document that has been disclosed in ordinary civil litigation. And it arises from the same root. The law says that where you have a party that can be compelled to produce documents, the quid pro quo is that they are kept in a state of confidence. And it is now much more usual than it used to be for the coroner to actually invite parties to sign undertakings in respect of confidentiality. As a matter of principle, there is absolutely no reason why we shouldn't be signing those, provided, and this I have had to do on a couple of occasions, you respectfully point out to the coroner that there are some omissions, for example, when material makes its way into the public domain because it's been used and deployed in open court, confidence should no longer apply. And equally, on occasions, you may need to show documents to a medical expert so that the family can understand better what it is being said about the disease process or the death process of their loved ones. Note, however, there is a subtlety here. When referring to medics, the fact that a document might be entirely relevant to civil litigation does not mean that it is relevant to the coronial process. And so the coroner will be quick to stop you if you're fighting breach, when in fact you should be concentrating on how the process of death occurred. But the counterblast is that particularly in Article 2 inquest, it's equally important that the families are engaged and feel themselves to be engaged fully where the state's duty to investigate itself has been triggered. And part of that duty on the part of the coroner's court is to ensure and to permit processes whereby families can have recourse to their own expertise. Oral evidence, as the Deputy Chief has just pointed out, a very, very useful aspect of coronial practice is that recordings are taken. I've got a written note of what I was going to say to you, and what I'm about to say now I've underlined in bold, and it says this: for the avoidance of doubt, there really can be no private recording made by a party of a hearing, however noble the intention. To do so is in essence a contempt of court, and that must never ever be breached. But usually a full warning will be given by the coroner before the proceedings commence. Interestingly, and I take this from the Chief Coroner's Guidance Note number 4, there is no particular restriction on the use of transcripts, providing, however, that you're not breaching any of the common law rules. So, for example, you're not naming the living victim of sexual abuse or anybody that's covered by an anonymity order. And this turns me then very briefly to the nature of the questioning before the court. I cannot emphasise too much that however much we have civil litigation in mind, and very often as lawyers we're only there because there is the prospect of civil litigation, and the engagement that we have is via a no-win, no-fee agreement, which is conditional upon succeeding ultimately within civil litigation, but the costs of representation at the inquest can be caught up within that order. Whilst I have a mind to civil litigation, I cannot breach the fundamental rule that the Deputy Chief has already adverted to, which is I cannot start asking questions which are seeking to shadow box in respect of civil liability, not least because the coroner is prevented by the terms of the Parent 2009 Act from making any conclusions that might be seen to be determining civil or criminal liability. But you can ask questions provided they fall within scope, and the advocate's primary duty here is on a sixpence to be able to stop and, upon demand by the coroner, answer the question, how is this relevant to scope? If you can't do that, you shouldn't be asking the question. But if you can do that, then by questioning in respect of the documents, you start to bring in to the public forum, and as the Deputy Chief has already made clear, this is a public forum, information about those documents that could be useful in due course. And those questions can be along the lines of, what does this document actually mean in a genuine spirit of inquiry? It can be asking a witness that appears to be helpful to the family's position, well, what more do you want to say about this document that's relevant to scope? And on occasions to say to a witness, well, look, what you've just said does not appear to be consonant with what's in the document. Does that mean that either you are wrong or that a very fine policy that looks great on the page was not in fact being carried out in reality? So once the witness has given their evidence on oath, it becomes a matter of record. And in the usual way of these things, because it's given on oath, they are liable if they drift from that in due course in subsequent proceedings to be at the very least pulled up short in proper cross-examination in those subsequent proceedings, and even on occasion perjury. But I've never seen a case of that yet. So to summarise the documents, documents may not be used in subsequent litigation unless they've been used in open court or there is permission obtained. Ditto witness statements, but evidence that's given by a witness in open court can be used subsequently, and that also includes the medical evidence, which can form a very useful rehearsal of the issues, including and in particular the views of the toxicologist and pathologist. I'm going to deal now very briefly with the coroner's conclusions, and I take what I'm going to say from the Coroner's Guidance Note 17. And the determinations of the facts and the findings as to identity, etc., contained in a record of inquest, which it's important to note is itself a matter of public record. The coroner is told to approach matter in 3 stages. Key findings of fact should be stated in oral process at the end of the evidence gathering. Box 3, as it's called, should be filled in with a fairly mechanical sentence as to the how that the death process occurs. And then the coroner can move on to box 4, the overall conclusion. And this can take one of two forms, either the short form or the narrative. I'm not going to go into detail about those because time doesn't permit. Of equal importance is the medical cause of death section, which is broken down in the traditional 1A, 1B, 1C and 2 categories. The category 1 causes are an increasingly wide explanation of why death occurred. So 1A will be the precise cause of death, the immediate cause of death, but there may be background causes and they are recorded at 1B, and then the one behind 1B is 1C. And cause 2 causes are those which are significant, which are perhaps not entirely the cause of the death, but not wholly unrelated. So what do you do with these findings? Well, they're not binding. They cannot be binding in subsequent litigation, because a moment's thought for the lawyers would understand that where, as I am, prohibited from making submissions of fact to a coroner, any determination that that coroner makes cannot bind me, because to do so would effectively breach my Article 6 rights on behalf of the client, or rather the client's Article 6 rights, because they would be bound by determination in respect of which they had not been able to make full submission beforehand. But even to worry about binding effects is to misunderstand the coronial process. This is an inquiry, it's an investigator. This is the closest the English law has to a juge d'instruction, and it's therefore not a court that is going to bind you. So if something happens that you don't like at an inquest, well, that's fine. The lawyers may still say, well, look, we'll go and investigate this afresh and look at it within the civil litigation. In respect to the prevention of future death report that the Deputy Chief has just referred to, that is extremely important. And against the MOD, it is very often that they will put up a witness for the coroner to question, with the sole intention of dealing with prevention of future death, because very often the MOD approach things by saying, when they are properly advised, we accept we got it wrong, that was then, this is now, this is how we've changed, and there is no need for a PFD. And that is a really sensible approach. I've been asked specifically to talk about real world examples where things have changed. I can give you 3 or 4. I'm going to limit myself to 2 because time passes. Both of them are IM cases. The first I did as a junior in 2009, Nimrod XV230, which was carrying 14 people across the desert in Kandahar, Afghanistan, when a fire started within the engine, leading to an explosion mid-air and a collision with the ground. And it was the single largest cause of loss of life for the military after the Falklands. And Irwins and I acted for, I think it was 13 out of 14 of the families. The Deputy Coroner then, Andrew Clark, went into a very great deal of detail about the history of this aircraft as a platform, and determined that actually it had never been airworthy. A quite brave approach that I'm not sure survives the 2013 rules. But as a result of it, the Nimrod fleet was grounded. There was then the Haddon Cave inquiry, which decided that as a platform it should be scrapped, and it never flew again. The second IM case is, I want to tell you about, and the last one I think I will tell you about, the Snatch Land Rover case. This was the death of 4 personnel in Afghanistan driving an unarmoured Snatch Land Rover. The Land Rovers were inadequate to come off-roading in Afghanistan, and so they had to stick to roads, and in particular little bridges over culverts. And the Taliban knew this and they watched. And they set IED devices, one of which took out the Snatch Land Rover in question. As lawyers, we prepared this on the basis that the focus of the inquest was going to be on the inadequacy of the vehicle. In fact, as it turned out, the real scandal was the inadequacy of the provision of metal detectors, so that when vehicles came up to culverts, they could stop and a scan could be had and undertaken to ensure that an IED was not present. And this was picked up by David Cameron just before the 2010 election. He put 6 questions to Gordon Brown, and then suddenly out of nowhere, Brown turned up in Afghanistan the next week promising £1 million for metal detectors. And I'm sure the 2 processes were completely unrelated. Moral of the story, inquests have a true real world effect. Thanks for listening.
Hi, Nicola, I think you're on mute, sorry.
Thanks, Donna. Sorry about that. Thanks, Mike. I just said there that the point that you made at the end really resonated with me about how inquests can actually have a real true life impact for individuals, and that leads nicely on, I guess, to Lesley and Neal's story and what their experience was following the death of their daughter Megan and the inquest process.
Yes, good afternoon, everyone. We need to start by saying we're both suffering from a granddaughter-induced bug, so apologies in advance for any interruptions. We'll try to get through this as best we can. My name is Neal Davison, and this is my wife, Lesley. Our 27-year-old daughter, Megan, took her own life over 7 years ago now, and her 2-hour inquest in 2018 proved unsatisfactory for many reasons. As a consequence, later on that year, we took advice from Irwin Mitchell and started legal proceedings challenging the hearing's conclusions in order that a second investigation could be conducted. Although negligence was considered at that time, we decided that individual culpability would not properly address the issue of systemic reform, and there needed to be a focus on collective responsibility for care that we felt was unfit for purpose. The subsequent 4-year appeal process included representation to both the AG's office and High Court, and in 2022 the original determination was quashed and a fresh inquest was granted. That took place earlier this year, and the 10-day hearing finally met the full, fair and fearless criteria demanded of the process. Due to 4 statements provided by our expert witness, the investigation necessitated increased interested persons and legal attendance to satisfy its widened scope. As bereaved parents, we have therefore experienced the 2 extremes of what an inquest can look like, and that inconsistency of process has to be eradicated. The second coroner exceeded our expectations, and the resultant Regulation 28 report was issued to both the Department of Health and our local Integrated Commissioning Board. We have now received PFD recommendation responses, and although there is general recognition of the need for systemic reform, frustratingly, after all this time, there are no guarantees of implementation. In essence, we believe that these recommendations are just an extension of the duty of care or due diligence initiatives that already exist within organisations. When a state death occurs, then the urgency to respond proportionately is accentuated, and it is beyond comprehension that there is no obligation for Regulation 28 report recipients to take any remedial action, whether they respond within the 56-day timescale or not. We are of the opinion that coroners need support to reinforce all the hard work that is required of them to reach the right conclusions. The best way to improve waiting times for inquests is to save lives, thereby reducing demand. This can only happen as a consequence of PFD recommendation compliance, and this issue has to be addressed for the benefit of all those adversely affected by the process.
Generally, the whole procedure puts any family at a disadvantage when they're already vulnerable. They're probably already completely traumatised by the fact that they're finding themselves in circumstances where an inquest is needed, and likely to be at a point when they are least able to cope at a time when they need to be absolutely on top of their game. Bear in mind that this is a whole new world that we didn't want to be a part of. You have no idea what the rules are or what is supposed to happen. If there is a mistake in the process or an action that you could take, you won't know, but it could affect the process going forward. We got sent completely the wrong information, which did affect the way we reacted, but we didn't find out until well into the appeal process. There needs to be someone on your side who can explain what's happening, what the rules are, and step in if something goes wrong.
As far as PFD enforcement is concerned, something mentioned earlier by Mr. Winter, supporting the charity Inquest's national oversight mechanism is essential for us, because if learning is the primary function of an investigation, then the monitoring of Regulation 28 compliance is crucial in respecting its integrity. Sometimes the only comfort bereaved families can take are PFD recommendations, but if evidence-based system failings are exposed at any inquest, then there has to be surety that there is compliance, as that will potentially save lives. How our loved ones died should be the catalyst to change and would validate their loss in the process. All we ask is that our long-term intrusive investment, the hard work of legal teams, and the due diligence of coroners is replicated by Regulation 28 report recipients. An independent body that has the authority to impose sanctions would ensure that all that effort is not wasted. There needs to be consequences for inaction, and on that basis, we wholeheartedly support Inquest's No More Deaths campaign.
A point that I think is worth making is that while the professionals may claim that after time has passed, they don't remember the specifics of one case among the many, this is huge for the families. They will remember, and that I think that needs to be considered because they will remember often only too clearly. Another huge challenge is the frustration of being disregarded, knowing your opinions don't seem to count. No facts changed between our two inquests. The only real difference was that we had an expert, and in amongst her evidence, she confirmed all the points that we had brought up and tried to evidence, but which seemed to carry no weight. If that's the way the system is going to work, then that needs to be clear from the beginning, and you need to tell the family that they need an expert and make sure that they are listened to, especially where what they're saying is verifiable. At the inquest, the family is going to feel totally outnumbered because whatever the intention, it is an adversarial process in fact. We deliberately focused on systemic failing and the need for reform to try and make it clear that we were looking for improvement and not vengeance. But you have to highlight the failure to show the need for improvement. The reactions feel defensive, as if the main concern is not to get sued or to embarrass the higher powers by showing that there is a need they're not addressing. It's the exception where the response is, yes, there is a problem, we do need more resources, and there is a training need. We also cooperated with internal investigations before the inquest, hoping that this would lead to some improvement. It certainly struck us that in our case, in the years as the evidence was revealed, there was opportunity for the interested parties to take the findings on board and come to the hearing with the proposals and solutions or some sort of progress in place. To any families, the failure to do that reinforces the impression that the attitude is not one of a willingness to improve, if at all possible, but to wait and see if they're going to be pushed reluctantly in that direction.
As far as the scope of an inquiry is concerned, the right decisions are the ones best informed, and we benefited from the delays we experienced as they accommodated more evidence, disclosure material, and procedural testimony. This meant we could be confident that the ultimate conclusions were arrived at for the right reasons, and we would have no regrets going forward. The breadth of scope providing more context is something that should be afforded all families going through this process, as it is imperative that all issues and concerns are fully addressed.
If this is about justice and addressing failings, why is it so hard to query an unsatisfactory outcome? We were lucky we had the resources, financial and emotional, to keep going, but not everyone is going to be in that position. And while that is the case, failings will be missed. To avoid unnecessary challenges, explain to families who are desperate for answers that there are advantages to taking a bit of time. Evidence may emerge, they will get stronger and can hopefully be in a better position to assess that evidence. Questions I have is that does a coroner know the history of the parties? Have they had other PFDs? Does it look like they have made changes? Because the families would expect that to be taken into consideration. Also, we have had some experience and have heard anecdotally that the promise made on the oath is being stretched. And if that is the case, and it can be shown to be the case that it's not really being followed, the coroner needs to react or to have the powers to do so and make it clear that there will be consequences when that happens.
We have had to educate ourselves both medically and legally to ensure we could adopt a hands-on approach and contribute to inquest preparation. As we are both retired, we have been able to devote the time necessary for us to achieve that, and it was important for us not to be perceived just as grieving parents. However, this is not the level of engagement most bereaved families can commit to, and it is therefore essential that there is support available that appreciates how difficult and confrontational this process is to navigate. On that basis, we would like to thank Irwin Mitchell for their empathetic representation and advice, and also the opportunity to tell our story here today. We are also grateful to the charity Inquest, who for over 40 years have been supporting people going through this process. We've learned so much from them over the last couple of years, and they provide comfort and compassion throughout challenging times. We speak to bereaved families on a regular basis, and this is a group no one wants to be a member of. For those at the pre-inquest stage, they just want transparency and honest answers so that they can come to terms with how their loved ones died. And for those post-inquest, they need to see evidence of learning so that other families do not have to go through this traumatic experience. All our stories are unique, but the issue of non-compliance has to be urgently addressed, as our loved ones deserve better. Thank you for listening.
Thank you, Lesley and Neal. That was really impactful. There were so many points that you made. I don't think it's possible to go over them all, but definitely what you were saying about the prevention of future deaths reports and compliance are the same. I think that's a key thing that people need to be talking about. It was interesting how you said about the coroner themselves needing support, but really the point that you made about families and how they can be at disadvantage and how they need support from everyone. And it's fantastic to hear how you're going on now and supporting others through the inquest process, and I know it's going to be hugely invaluable to them at such a difficult time of their lives. I think we've got a couple of questions, and I think the first question I will probably open up to Derek and Michael when he returns to the screen, hopefully soon. There he is. We've been asked, what power does a coroner have to direct disclosure of expert evidence that has been obtained in a civil claim? And also, if a coroner instructs their own expert, can that evidence be used in the civil claim as well? So if I go to Derek first.
I'm going to say it depends, because it depends on so many variables in terms of who the expert was, what the views of the other parties might be in the associated litigation, what the views of the interested persons might be within the inquest process. I try and work with a degree of consensus, which is why if we're having an expert in an inquest hearing that I'm overseeing, I prefer to have an agreed letter of instruction, an agreed expert if at all possible. Sorry. So as I say, it largely depends. Experts can be very helpful, particularly when there's a conflict over expertise, because I don't have expertise in every single matter that comes before me, so I need guidance too. Hence, my view is that I get a court-appointed expert to assist me, and I will pay for that. Families can be at such a disadvantage when faced with the funds that others involved can muster, and Lesley and Neal giving their account demonstrate what I see a lot of, which is what great advocates family members can be for their loved one, and I always try and recognise that at every inquest.
Thank you. I wouldn't disagree with a word of that. I think for the questioner, we probably need to think through the logic of the position. Only expert evidence that had been disclosed by the claimants to the defendants in civil litigation would be amenable to such a direction, because it wouldn't be obvious that material was held to anybody else unless it had been disclosed, and B, until it is disclosed, it's protected by LPP, and short of a direction that no coroner would give, because there would be significant ramifications if that attempt was made, would direct against. So it would only be where there had been disclosure. Now, if it's been disclosed, ex hypothesi, it is helpful to the position of the family, in which case, to go back to what Mr. Winter has just said, it would be a matter of no doubt, agreement subject to issues or relevance, where I, on behalf of the family, would say, yeah, fine, please have it. Because it will help the coroner discharge their duty, and it will help you, other interested party, defendant to be, to understand where we're coming from with this, not least because now there is going to be some public discussion of it. And a well-advised defendant will often settle rather than go through that process, because, again, the MOD is a good example of this. It is part of the package to say to a coroner, look, there's no need for PFD here because we hold up our hands. We've held up our hands and we've made settlement. That's part of the background. And having held up our hands, we realised there was a need to change, and these are the changes we've made. So I don't think it's too much of a problem in terms of the coroner's own direction. What's the matter for them as to their own expert? But as somebody representing an IP, I think it's always incumbent on me to point out to the coroner that there are two options. One is that the coroner goes to their own expert, or second, the coroner permits interested parties who have the resources and the backing to do this to put in their own experts, and each have strengths and weaknesses. The coroner's expert might be neutral and maybe middle of the road because they've got no experience. And I'm thinking specifically of some debates going on at the moment in respect of footballers and heading the balls, and whether that leads to TCE, CTE. On the other hand, experts who are called by interested parties may set out the extremities of two sides of a debate, and a coroner may think that helps them to get to the middle ground, and it will depend on the facts and the circumstances, and indeed the coroner themselves.
Thanks, Mike. That's really helpful. We've had another question as well from a healthcare professional who wants to know, and this is really put to all of you, if somebody is going through a civil claim process and that person chooses not to take any advice from a solicitor about the inquest process, what should they do? Is that, you know, something that you think somebody should step in and advise them to speak to somebody, or do you think that they're well equipped, I suppose, to go it alone? Let's start maybe actually with Lesley and Neal. That would probably work well.
Obviously, because we chose not to pursue any civil claims after the inquest, you know, it doesn't have too much relevance to our situation. But I mean, I would always say that, like I mentioned before, that all the best decisions are the most informed ones. So, you know, the more information you've got and the more advice you get, the better the circumstances. So, you know, I would always suggest look for whatever support you can find.
Brilliant, thank you. Derek? Oh, sorry, you were just on mute.
Sorry, in my experience, most employers look after their employees. They have a vicarious liability to do that. But in certain circumstances, at a pre-inquest review, if I was of the view that there may be an actual or potential conflict of interest between the employee and the employer, then they should seek separate status to look after themselves, because there's a risk that the employer may not look after the employee. And many healthcare employees will have access to potential insurance, potentially via a trades union, or a doctor may have indemnity insurance, for example, because the last thing the coroner would want to do is to get to the hearing and all the months that go by, only to find that when they get to the hearing, the employee who needs that advice does not have that advice available and the case has to be adjourned. So a pre-inquest review is a good opportunity to do that stock-taking exercise to make sure that when the hearing is listed, it proceeds and within the timescale provided for. So information is power if you are going anywhere to familiarise yourself with what you might be faced with. And it doesn't infer culpability if you have your own lawyer, but I take on board exactly what Lesley and Neal had explained, how they can feel overwhelmed by the presence of others who turn out in such numbers. So it's for coroners to try and manage all of that, the family at the heart of the process, but others can face jeopardy at the process and should potentially take their own advice. Coroners can't make them, but at least get some initial advice.
Brilliant.
Completely. So in my neck of the woods, which is usually industrial disease, the thoracic nurses are very good at saying, look, go and see a lawyer. They don't necessarily recommend who, and they certainly don't to make clinical governance dependent upon whether they do or don't. I'm not particularly carrying the torch for those who may be in difficulties before the coroner. As Mr. Windsor said, that there are those who have got questions that are going to be asked of them that they need to answer, but I do in respect to the families. And I think it's important for families to remember two things. The first is that one of the glories, and I mean this, I know it sounds sententious, but I mean it. One of the glories of my job is that it is my role, supported by the solicitors, to act as a complete counterweight to whoever the large interested party is, whether it's the MOD, whether it's the NHS, whether it's government department, doesn't matter who it is. BA in aerotoxicity, for example. It is my job to make sure that within the rules, my family do not feel intimidated. And very often it's an easy job because the coroners now are almost superbly attuned to this. It compared to, and forgive me, Derek, putting it this way, some of the dinosaurs that roamed the scene 20 years ago, they're gone. And the modern coroner, in my respectful experience, gets this point in buckets that for the families, for ordinary people that didn't ask to be there, it's massively intimidating to see people in shiny suits from London on behalf of large organisations, and that's where the lawyers can help. What I would also say is this, that there are some cases that come along, and a lot of them through Owens, through other solicitors as well, where it's not likely that there'll be civil litigation, but there is something about the factual circumstances that mean that representation here is just necessary, and there are certain occasions where we'll do it anyway, just because the justice of it is important. So yeah, think about lawyers, but we're not the be all and end all. And the other thing to say is this to anybody that would be concerned: civil litigation is not a train that you cannot get off. You can think about civil litigation; it may just never happen, and that's fine. Nobody's going to force you to do anything.
Brilliant. I'd like to say thank you to everyone for joining today. I'm a big believer in saying that everyone should be able to make an informed decision, and as Lesley and Neal were saying, you know, the best decisions are those informed ones where you've got all the knowledge that you need to hand. And obviously that's a really key point here with the inquest process, that you need to have all the evidence before you and be able to consider the same to be able to deal with it, as you so rightly should at a difficult time of your lives. I would like to say to all the people who have joined us today, this recording and copies of the presentations are going to be shared, as we said before. And we also have a bereavement conference on the 5th of December. That's going to be held in Manchester. We've got a wide range of speakers there. The link will be sent out in the email follow-up, so please do join us if you can. And thank you once again to everybody for joining us today.